Well, apologies for the technical difficulties, those who were waiting for this live. But welcome. I've just been told not to bump the table, and Josh is moving the camera, mind you. Welcome to Justice on Tap. My name's Ben Franklin, Managing Partner of NWF Lawyers, and here this evening I've got a couple of our colleagues, Harrison and Josh, helping me out as we look to answer a few questions that people have popped online. So thank you very much for engaging and throwing through your comments. The questions are particularly adept and frankly quite relevant to some of the matters we're running. So if you're a client of ours who's looking to check our advice against what we've told you, hopefully we say the same things. If you're on the other side, hopefully we say the same things we've told you in our letters. But it is St. Patrick's Day, so it would be remiss of me not to start with an Irish joke. I told the boys one earlier, I'm not using that one. It's not appropriate, but this one goes like this. The court opened and the judge read out the charges. And then the judge asked Murphy, who was standing in the dock, "Are you the defendant in this case?" And Murphy looked at him and said, "No, sir, Your Honour, sir." Murphy replied, "I've got my solicitor to do the defending. I'm just the guy who did it." So that's an age-old tale of clients, and I'm sure poor Murphy's solicitor was sitting there going, "I told you to say nothing, son." So the first bit of free advice I'll give anyone, just give a no-comment interview, all right? Just do it. Just do it, okay? Ring your lawyer, get your lawyer down there, and don't say a thing until then. We don't do a lot of criminal law here. Ben Green's our criminal lawyer. I won't say any more things on criminal law because I'm no good at it, but that is an absolute fundamental. But you know, without any more further ado, it is Justice on Tap. So we're having a beer. It's St. Paddy's Day. So cheers to everyone out there having a nice St. Patrick's. We've got some theme music in the background from one of the local venues. Thank you very much. I hope you're enjoying yourself a Guinness, or in this case, a nice fresh lager, XPA or something else. I'm not sure what we're drinking, but it is delicious. Harry's looking at me looking like he wants to ask me a question. So go for it, mate. What are we talking about?
Well, we've got a few questions today,
going
from property law to employment law, all the way to wills and estates and trusts. But I thought we'd start off with something that is quite relevant to a lot of people at the moment, going through new builds or buying properties and wanting to build on them.
Yep.
We have a question from one of our question submitters. What are the risks of building a structure on your property without any of the correct permits?
Yeah, great question. I mean, obviously, if they're the correct permits, it suggests you do need a permit. But the first question to ask is, do you actually need one? Now, I think gone are the days where you can just put up any old structure and not ask the council for permission. The reality is that most structural builds on a property of any sort, whether it's residential, whether it's farming, whether it's commercial, there's likely to be some level of permit requirement. So two types of permits, one are planning permits and the other is building permits. Most people think of building permits because planning permits, a lot of us would expect to be able to do what we're trying to do as an extension or a backyard or decking or these sorts of things, that it's a residential project. But first thing to check is that with the council itself, and to go and have a chat to them about whether you need one. If you don't want to do that, then I can't tell you that that's okay, because it's not. It's unlawful, and there's fines and there's a raft of penalties and issues that do arise from it. But if you go ahead and do it, or if you've bought a property that you're not sure if there's permits on the buildings or the structures that are there, what can you do about that, and what are the risks? Well, in short, the Building Act has a raft of provisions relating to what you can and can't do and whether you need a permit. And if you're doing something without a permit, you're probably doing it with someone who's not necessarily qualified, or at least not following their qualification requirements in terms of their registered building status with the Victorian Building Authority. So that's the first thing to remember. is it's a tale of caution because you're working with someone who's willing to cut the corners. If you're going to do it yourself, if you're someone who's handy and you're good enough at putting things together, I certainly am not. These hands do not do hard work. They are lawyers' hands. A funny story about that with one of my great aunties, but I won't go into it. So, in short, don't do things without a permit. But if you've done something without a permit and you want to know what the risks are, the biggest issue is when you're on selling, okay? Before that though, the council do take aerial photos, the council do monitor these things, they do get tip-offs, and if they find that you've done something that required a permit and you are not, have not followed the protocols, they can issue you with what's called a building notice. Okay, so building notice is, hey guys, we've noticed you've done this, different type of notice, but notice with a little n that you've done this, and so here's a building notice with a capital N. Tell us why you shouldn't have to knock it down. And frankly, that's what they can do. They can actually order you to knock that premises or that structure or that whatever down. And if they're going to do that, then you've somewhat got to wonder whether that was a good idea in the first place. There are ways to get retrospective approval. That's not possible on everything, but it is possible on some things. They're not entirely unforgiving, but you do usually have to pay a premium and you've got to engage your own building surveyors and these sorts of things. So that's the first thing you can look at doing is retrospective approval. The next problem that you have is if you're trying to sell the place, because whilst it's okay or it's been accepted that purchasers have to accept a non-building permitted structure once they've settled on the property, there's a section in the Building Act called 137B, capital B, and that basically says if you've done works that aren't by a registered builder, that you need to make sure there's a report about those works. And that report will say that there's no permit for it because that report writer will ask for the permit. If you've done that, then there's a whole raft of issues with trying to get insurance for those works. And you're taking them, a builder if they're not a registered builder. And if they're a registered builder, they would have got a permit. So you see how it sort of flows into a situation where a purchaser can pull out of the contract if you haven't followed these processes right up to the day of settlement. So ultimately, the lesson to be learned is don't do things without a building permit. Go to the council first, ask the question, pay the money, get it done. It is a pain, we understand it, red tape, all these things, but ultimately what you've got to understand is you're actually buying insurance for your future of what you're doing with that structure and what you're doing with that property. You might not ever make a claim on your insurance, it doesn't mean you don't pay for it, it's the same sort of thing. And you're also making sure that you've got a third party looking at that structure and going, it's safe. So most things that require a permit have structural integrity issues and risks. You don't want your kids, you don't want someone else's kids going and playing under a structure you built, didn't get checked, and then it falls down. So don't do it, but if you're going to do it, know that there are risks.
Very good. Well, moving now from the property law side of things and building to something that's going to be on a lot of people's minds as well, particularly coming up to end of financial year now, people are going to be wanting to jump ship, maybe get a new gig. Are non-compete contracts or clauses in contracts enforceable for employees and employers? Yeah,
absolutely. Please don't tell me it's the end of the financial year yet. I have a lot more work to do. But you're right. I mean, ultimately, particularly in the current market, and particularly the market that was created by the COVID sort of employment, working from home and all these things, we're dealing with it as employers all the time. There is constantly going to be shifts and moves in the professional services market, particularly. Are a restraint of trade clauses enforceable? As an employee, very rarely is the court going to actually uphold a restraint of trade if you are just a PAYG employee. In order for that to be the case, there needs to be a range of factors the court finds in favour of the restraint applying. And those factors include effectively whether or not the business is genuinely in need of the protection and whether or not it's appropriate in our structured legal system for that sort of anti-competitive conduct. So we have the Australian Competition and Consumer Commission, the ACCC, and Australia's market is defined as a free and open market, and that's ACCC's job to make sure that that's the case. But it goes to the policy principles behind that, which is that it's the public interest that people are allowed to work for their living, and they're allowed to do so in a free and open marketplace. So basically, they're not enforceable unless the court thinks it's appropriate to enforce them. Usually in employer-employee situations, someone has to have been paid a premium upon their exit for there to be some sort of a binding restraint. Because of the reality that unless that's the case, they're entitled to go and earn a living the next day at a different job. That can change once you get into more senior positions, and restraints of trade tend to start really being relevant as you get to senior management and to a higher pay bracket, particularly in respect of client services where clients might follow that individual. So it doesn't necessarily have to be that though. We actually have an example of a recent case where there was a person working in the beauty industry, and they were working in a country town in Victoria, and the court actually found that the restraint was binding on this individual within 5 kilometres of the premises of their employer. They had 1,900 clients that they'd serviced over 5 years in their beauty services business that ultimately the court banned them from dealing with for a period of time if they were operating within 5 kilometres of the original premises at which they were employed. So it's not that that there's just no way of ever making it binding. It's very much about the type of business you're in, what you're being paid to be in that business, and whether or not it works out in the business's favour. The position that we are finding ourselves in a lot of the time is that professional services have moved to alternative protections. Information protection, that is confidential information and confidential clauses, but also liquidated damages clauses. And now in Australia, liquidated damages clauses are not banned and are not voided by the law and the public interest. That is, if you move and you take clients with you, you'll pay us for those clients and the value that you take from our business. That is something that you need to be really careful of if you're an employee in a professional services space. And it's something that, as an employer advisor, we're telling a lot of our employers that they should be adding to their to their employment agreements. If they have a person who's taking up a senior role and so have that client rapport, that's an important asset of their business that requires protection, and that's another way to do it. So are they enforceable? Usually not. It's not in the public interest unless the court thinks that it is, and it's a bit of a case-by-case scenario, and it's literally what the courts say. It's a case-by-case, we'll consider every case on its merits. What we ultimately find is it's just a cost-benefit analysis. The employee, can I afford to be sued? The employer, how much is it going to cost us to not sue? And therefore, they're in a lot of employment contracts as a motivational proposition. I'm trying to motivate the employee not to compete against us in our local market by the risk of them being found to be at fault or to be guilty of breaching their restraints. And that's ultimately where it comes down to, is a leverage mechanism a lot of the time in our employment contracts that we're drafting. But they do get enforced, as that beauty therapist found out, which was a huge change for that person. Like, most people would have expected that wouldn't have gone through. But small country town, word of mouth is very important for that business. Therefore, the court did find that it was an appropriate thing to restrain her from operating within a very close radius of that business for 12 months from leaving the business. So, it's a bit of a yes-no answer, frankly. But that's the way they work, and it is up to the court, ultimately.
No, makes sense. Something that we're putting in a lot of our contracts at the moment, just to make sure that there is the option for these types of clauses to be binding, are ladder clauses.
Yep.
But we're finding a lot of clients don't understand those. What is a ladder clause?
Yeah, ladder clause, or also known as a cascading clause. So they're clauses that effectively, there's multiple options within the restraint. So you might find that it says that you are restrained within the restraint period, and you're restrained within the restraint area. And then you go to the definitions, and restraint period says 5 different periods. It might start at 2 months, it might go out to 5 years, and then you might have restraint area is 5 kilometres out to the whole of Australia, and different categories. And then you'll have something like a statement in that clause that says each individual restraint period and restraint area is combined with the other to create its own clause. And effectively, the way you have to read that clause is as if there's if you've got 5 times by 5, you've got 25 different versions of how that clause could play out. And so effectively you've got to read the contract as if there's 25 different restraint areas and restraint periods that work together and build that ladder. And the reason we're doing that is because the law says that the court will read down the contract sufficiently to make the restraint the most appropriate that the court thinks is available to the situation. So it might feel that in that instance I was telling you about before, that case, the restraint was also for 25 kilometres and it was also for 4 years, for example. But the court found that no, that wasn't really reasonable. And so what these restraint ladder or cascading clauses create is the ability for the court to find the perfect middle ground that it feels is appropriate in the circumstances. Does it always work? No. Does every time you've got that in a contract guarantee you an enforceable restraint clause? No. Does it increase the likelihood of the restraint clause being effective? Absolutely. And ultimately that comes down to the contract review principles associated with, well, if I'm going to read a contract down to an appropriate level of restrictiveness, if I don't have those options, I can't do that as a judge. So a judge can only read the contract with what it has in it. They can't add things to the contract. So it's about giving the judge options. That's effectively what they do. So hopefully that helps people understand it. If you don't understand it, that's okay. Come and talk to us. We can explain it. Doesn't take that long. And each individual case is case by case. So you may well have ladder clauses that make a lot of sense, or you may well have ladder clauses that are ridiculous. And we can explain whether that's the case and what your risk factors are. Before you sign it, ideally, if you've already signed it and you want to move, before you leave, we've done all that sort of work and we can help with that.
On that point, is there anything that I should look out for when completing an enterprise agreement with my employer? We've looked at very specific clauses, but in a general sense, What should I be looking out for?
Look, enterprise agreements are what an employer will, usually they're quite a big employer, so there's usually, we don't see them in small to medium-sized businesses, we tend to see them in larger businesses. But an enterprise agreement is effectively a way where the business can enter into a general agreement with their employees where the award is overridden by the enterprise agreement. Look, I'm not an employment lawyer in that space. I don't do those sorts of agreements as much. So I will caveat with saying this is at the very edge of my awareness in terms of what we do. But enterprise agreements as a general rule are there they have to be more generous and they have to be approved by Fair Work. So they have to be more generous than the award in some aspects at least, so that it justifies taking away from other protections that a modern award might create. And some businesses might do that because the modern award doesn't suit their particular style of business, but it applies to their business because of that general characterization of what they do. So ultimately what you need to look out for with an enterprise agreement is all of the materials around what Fair Work has said about it. Usually there is a joint representation approach for the employees. Obviously, if you're coming into a business that has an enterprise bargaining agreement in place, then you need to consider that as part of your contractual rights and know that you're not going to be able to rely on the award. You have to look at the enterprise agreement that you're actually entering into, and you can't rely on that general award protection. But ultimately, it just comes down to your contractual arrangements with the court, with the employer, because an enterprise agreement, like a modern award, overrides any contract that is not consistent with it. And so really you just got to make sure that your contract, is someone that you're willing to work for, because usually the contracts will refer to the EBA and the EBA will be very clear on what is and isn't allowed and isn't fair for you. And know that you can't go back to the award and say, I've been paid lower than the award. Well, if that's allowed under the EBA, then it's allowed. Now, why is that allowed? Well, usually it's been allowed because there's benefits elsewhere. And the business style requires that. So if you need an EBA reviewed, let us know. We can put you in the hands of the right person. It's just not me.
Well, let's talk about what you are the right person for. We've got a question regarding debts.
Nothing, we're finished. Good. No, debts, yes.
What happens to my debts when I die?
Your mum pays them. No. Debts unfortunately do live on beyond you and beyond your death. So there's no simple way to just rack up a large debt on the way out and then find yourself thinking, oh well, my family's benefit that I left them in my will is safe. Ultimately, when we put together what's called an inventory of assets and liabilities to go to the Supreme Court and say this person has passed, please give the power of administration of their estate to whomever their will says, or in the case of an intestacy, to the most appropriate person, there's actually a process by which creditors can apply for probate. And that is people who are owed money by that person are able to actually force the probate process to progress so that they can then appoint an administrator, and usually that's someone who's independent but has some experience in the industry, and that person then is able to take control of assets and sell down assets so that the debts can get paid. I've got quite a significant estate that I'm involved in at the moment where we have debts with the tax office, debts with the bank, debts with work cover because the person was involved in employment of people leading up to their passing, and there was just a bunch of loose ends because unfortunately sometimes we all know that these things can happen without expectation or prediction. So unfortunately loose ends don't just get cut off, and you do need to consider your debts as part of your estate planning and your succession planning to make sure that those who are being given the reins and asked to look after your affairs after you're gone aren't left having to handle a very awkward and significant issue if you can avoid it. Like I say, sometimes it happens and it is the way that it is, but certainly don't go out thinking that you can take a bunch of money from your employer and knowing that you're on sick leave to the end of things and you didn't think that was going to be an issue. You don't get away with that, and there's plenty of estates that have been made to feel and a lot of executors who've been made to feel very poorly because they've been put in that very awkward situation. Being an executor is hard enough, frankly. So I do that job sometimes as an independent, and it's not easy. So it's definitely not worth making that harder for the people who you're putting into that role. Hopefully that answered the question.
No, fantastic. So let's say that the estate is in the green, so to speak, and there aren't debts that have overtaken.
You can tell Harry's paid too much. He thinks of money as green. But you mean the black?
That's right.
Very good.
Just not in the red.
Yeah, not the red, as long as we're not in red.
Well, now I'm going to give you another scenario. Which
Okay.
is that if money's been left to me,
Yep.
how do I access it?
Yep. Okay. Very good question. As a beneficiary of a will, the estate executor should reach out to you at some point during the process. Now, that can take a little while because getting probate's the first step. Okay. So probate is the process of taking a will. Usually you've got to have the original. You've got to check to make sure it's been executed properly. And then you've got to make some inquiries as to the assets that you're going to take control of as the executor. Usually that's done with the assistance of a solicitor, and we help many hundreds of people every year do that job through our firm here. And ultimately, once you've got a decent idea, you don't have to have a perfect idea, but you have to have a decent idea of what's in the estate. Once you've got that idea down pat, you submit an assets and liabilities inventory to the Supreme Court with your grant of probate application. That then obviously becomes a public document. So the grant of probate, every grant of probate in Victoria's long history, it should be available to review. The Public Records Office of Victoria has the hard copies of every probate file going back as far as I'm aware. And subject to the odd flooding event, my understanding is they have mainly converted a lot of those to digital files now. Where that obviously leads to is that even if you're not being contacted, if you feel you were a beneficiary or you should have been, you're entitled to see a copy of the will, and you're entitled to ask for that of the executor who has the control of the will. And then even if they're not answering that request, or if they're not dealing with you, they're refusing to deal with you, in order to deal with the estate, they have to get probate. and then the probate file becomes a public record and a public document. You can go to the Supreme Court, explain your relationship with the deceased, and they will provide you a copy. Once you get to that point, whether it's by virtue of your executor contacting you or your own investigations, you then have the ability to call upon the executor to pay you your entitlement. Now, what does that look like? Usually an executor will be reaching out to beneficiaries and saying, this is what you're entitled to. Here's a list of what we've done with the estate and why this is the amount you're entitled to. So if you're entitled to all of it, well, the costs, the debts, these other things have to get paid first, and then we result in a final distribution towards the beneficiary or beneficiaries who are entitled to the share of that. So what should you do? If you're not sure, if you haven't heard, check the probate advertising website. That's through the Supreme Court of Victoria. They've moved that into what's called a portal called Redcrest. Don't ask me what that means. I think it's because the crest of the Supreme Court is red, and so they haven't gone very far with the originality of that. But they have Redcrest Probate, and your advertising is now done online through that. That is obviously where you can go to see if someone's applying for probate. If you have a concern about someone applying for probate, if you think they're not appropriate for the job, if you think that they're trying to get probate of an old will that's no longer relevant, then there is further processes. And so that's why it needs to be advertised. But you only have 14 days until they can apply for probate. Once they apply for probate, that again goes into the public system, and there's actually a probate index that sets out the applications that are made. So you should be checking that website if someone that you think you would be entitled to a benefit from has passed and you're not hearing. Check that website, reach out to the solicitor whose details is on there. If they're not responding, engage a solicitor and get some letters written, because usually that means someone's not quite towing the line.
Fantastic. On that note, solicitors have a lot of confidentiality requirements. But in a general sense, can you talk to us about the rules surrounding a non-disclosure agreement or NDA?
Yep, absolutely. NDAs are notoriously fun to consider. It's kind of a cool thing to do because you think, because I think it plays to the concept that what you're talking about might actually have some value. So of course you want an NDA to be relevant to you because it means something important is happening that you've come up with. So NDAs are non-disclosure agreements. They're a commercial contract. It's as simple as that. There's no mystery to them. It is literally whatever the document says applies to you and the person who signed it with you. So basically the idea is that if you are going to share an idea or you're going to share proprietary information, and then that word proprietary is a really important one in intellectual property law, that if you're going to share that sort of information that you wish to keep confidential, you are binding the person who you're sharing it with to the obligations under that agreement, under the NDA. Some NDAs are 1 page, some NDAs are 20 pages. It very much depends on the seriousness of the transaction. And usually there's a transaction foreshadowed, i.e. I want to buy your business, you want me to buy your business, I need to see information that's relevant to your business. That includes things like client names, processes, potentially patents, intellectual property, trademarks, things like that. And I'm going to commit to you that in order to review that material, I will commit to you that I won't share that and I won't misuse that. If you're the person sharing the material, you want that commitment, because if somehow that material gets out into the open and the only person you gave it to who could have revealed it is the person who signed an NDA, then theoretically and hopefully practically under the agreement, and particularly if it's drafted by a lawyer, you would have the protection of that agreement to be able to seek what's called an injunction. That is, if you think they're going to release or misuse the information, you can get a court order to stop them at a first instance. And even if they have already done it, then you can seek damages if that information release has caused you loss. So NDAs can be quite useful, but you've got to remember, and the best way of drafting, or what we try and do when we're drafting NDAs, is make sure that the disclosure agreement is easy to enforce. That is, that there's a really clear damages process to follow. That is, that if you release this information, this is what I'm going to do to you. And that there's an element of consent within the agreement that the person who's revealing that information unlawfully and against your contract, that person knows is going to be the case. And the court then looks at you and goes, well, you warned them, they did it, we're going to make sure that you're protected. And the biggest issue with that process is legal costs. Legal costs are not to be trifled with. They don't often result in an order that you get all of your costs back. It's a bit like Medicare, it's a bit of a gap usually. But if you've got a really well drafted NDA, then you should have that protection as well, and you can go the whole hog, really protect yourself, protect your ideas, protect your information. And in this day and age, information's key. Information's king, so they're becoming more and more relevant.
But what if I'm looking to save some money on legal fees? Do you have an opinion on if ChatGPT or other large language models or AI models are good for looking up the law or creating documents?
I need a new drink for this one. No, look, I think this is without condoning any particular brands, but it just happened to be the one we had in the fridge. ChatGPT. What shall we do with you? The general position with AI models, open source models in particular, thank you, Harry, in this space is that they can be a great inquiry leader. Okay, so what we're saying to a lot of our team and people who come to us with AI information is, look, yes, the information generally is a good place to start. But then again, Google always has been. And so, you know, what you tend to get in that space is something that will follow a very particular pattern and what will follow a very particular understanding in the general space, but it won't be necessarily tailored. Sometimes that's sufficient, and there are generic template, softwares out there that people can log into and generate their own template, and off they go. Can that work? Absolutely. Is it guaranteed to work? Well, I'm pretty sure the disclaimers on those websites say no. So it's really about taking that general information that you can get from those resources, whatever they are. And AI is not new. AI is just developing, right? As I said, Google's been doing this for years. As a uni student, I used software that was able to find case references from multiple international sources, multiple courts around Australia, going back 50, 100 years. I mean, the reality is we had the ability to look this stuff up and find particular references to particular cases, and we've had that ever since I've been practicing. What we're now getting is an AI's interpretation on what's relevant and what's not, as opposed to us just getting a keyword search, which used to be the old version. And so what you've got to be careful with is that someone hasn't trained the AI badly, and making sure that you're getting it checked by someone who's actually practically implemented what it is that you're looking to implement. Because practicality and example and test of time and test of the mettle of humans and these sorts of things are all factors in contractual interpretation, in contractual implementation, and ultimately in enforcing your rights. So, is it a way to save money? Yes. Are we using it? Absolutely. Are we using it to its fullest potential? We're still learning. We are trying to add the efficiencies that AI is bringing to the industry to our clients' benefit. But would I suggest that anyone just goes out to ChatGPT or the like and say, please draft me an appropriately written non-disclosure agreement? No, because ultimately you're at risk of getting a non-disclosure agreement that's relevant to Pittsburgh, Pennsylvania, because that's the last time that it was put into the open source system. We've got to remember law, particularly in Australia, is state-based predominantly. So an NDA, whilst it may have some general consensus across different jurisdictions, is interpreted differently in Victoria than it is in some other states here in Australia, and certainly differently in other countries. So that's the other reason you've got to be very careful. I was at a seminar on Thursday last week, and we addressed this very point, and they said unless you're getting it from a Victorian source, you have to be very, very careful. And even from a Victorian source, you still have to know who's feeding the information in. That's a lot of work for you to do as an individual who doesn't know what they're not knowing and what they don't know. Yeah, absolutely. Would we look at a draft that you bring us from and would it save you a little bit of money? Maybe. But ultimately, we're trying to bring that efficiency anyway with our pricing models. So come and ask us first. If you think you can do it cheaper off the back of that, good luck. But I reckon we're probably going to give you a better product for the price you pay. That's the key part. You get what you pay for.
Speaking of the product, we have talked about quite a few different practice areas.
Yes.
What does NWF lawyers do?
Nothing. No. No, it's a great question. And it requires a little bit of context of history. So the firm has gone through different phases, and we're now in a phase where we're trying to grow, and we're trying to make sure that we can offer as many different services as possible, whilst also trying to make sure we're good at those services. We're not just doing it because someone asks. If someone brings me an EBA, I'm honestly not doing it. I'm either referring it to a barrister that I know who can give us that advice, or I'm referring it to a lawyer who's got the skills, whether that's in-house or if we don't have those skills in our office, then I'm saying to the client that's not what we do. But what do we actually do? Key areas: wills and estates, family law, property. And when I say property, that's obviously a very broad concept. Everyone's deals with property in their lives. But when I say property, I mean property transactions: commercial, residential, difficult dealings with the Land Titles Office, Land Use Victoria, all the departments that deal with licensing of land and Crown land and these sorts of things. So there are three key models, I suppose, that we sort of work through. And we do have criminal advocate lawyers here and defence advocates who help with that type of work. We do have more general commercial transactional work as well that we do for a lot of our clients. So buying businesses, selling businesses, and again, that comes a lot under property as well. There's usually a property involved, or there's whether it's residential or real property, or land, or whether it's property in the phase of assets and these sorts of things that comes under our property arm. So our website sort of works through your business. And these sorts of things as its model in terms of how you follow through what we do, and there's plenty of information on there about how we can help you. But hopefully it's easy to find. If you've got a question, more often than not, our website will tell you whether we can do it, and if we don't, we'll tell you. We've now got 35 staff across 4 offices here in regional Victoria. We've got Melbourne presence as well. We tend to be able to cover most legal queries at a first instance, and where we don't have the expertise, we know where you can find it. So, and we won't gild the lily there. We'll make sure you're in good hands either way.
Now, what's up for the next podcast that we do?
Hopefully it's live. We'll work on that. Maybe not. I don't know. Maybe the cut down version will be better. We'll wait and see. We just want to understand what people need. So part of our process with getting into this space is to say, look, what we do is not overly unique. There's a lot of lawyers. There's a lot of people who can answer the questions I've worked on tonight. I'm certainly not the only person who can answer these questions, even in our office. And frankly, the person asking them could have answered quite a few of these, and we've got all manner of expertise in our team. So what we're trying to do is just basically bring it to you guys and say, hey, get online, get a feel for what we might know, what we might not know. If it is an easy answer and you just want it verified because Google's told you one thing and ChatGPT told you another, then ask the question. But what we want to build is a community. We want to build a conversation, and so what comes next is really up to the people who are listening and watching. What do they want to see? within reason. I'm sure it's nothing untoward, but we're here to, have a bit of fun, have a beer. We might move it around. We might, this is my office, but we may well change our venue, and we'll be talking to some of our clients who have some hospitality venues about whether or not we might be able to set up, in a corner somewhere with, maybe a few more promotions about, if you ask a good question and you're in the audience, you might, have your drink shouted for the night or something like that. Because really we just want to put out there what our knowledge base is and to let people know what we can do, and to, really hopefully get people engaged with our brand and engaged with what we want to do, which is to help. We like to get paid for that, but at the same time, we like to be good at what we do, and we like people to talk about what we do. So if we can help people understand that and get the conversation going, perfect. That's what we're up for. So you choose, you help us help you. Simple as that.
Fantastic. Well, Ben, thanks for your time. Cheers.
Cheers all.
Cheers.
Justice on tap. Happy St. Patrick's Day. I've nearly said something different then. Sláinte.